Please be seated. The sitting is open. The court meets today to render in public session its decision on the request for the indication of provisional measures submitted by the Democratic Republic of Timor-Leste in the case concerning questions relating to the seizure and detention of certain documents and data, Timor-Leste versus Australia. Proceedings in the case were instituted on 17 December 2013 by the filing of an application by Timor-Leste against Australia. On 17 December 2013, Timor-Leste also filed in the registry a request for the indication of provisional measures. By its request, Timor-Leste sought to protect certain rights which, in its view, are affected by the seizure of 3 December 2013 and subsequent detention by agents of Australia of documents, data and other property which belongs to Timor-Leste and or which Timor-Leste has the right to protect under international law. In particular, Timor-Leste claims that these items were taken from the business premises of a legal advisor to Timor-Leste in Narrabundah in the Australian Capital Territory, allegedly pursuant to a warrant issued under Section 25 of the Australian Security Intelligence Organisation Act 1979. The seized material, according to Timor-Leste, includes inter alia documents, data and correspondence between Timor-Leste and its legal advisors relating to a pending arbitration under the Timor Sea Treaty of 20 May 2002 between Timor-Leste and Australia. By a letter dated 18 December 2013, in my capacity as President of the Court, acting under Article 74, Paragraph 4 of the Rules of Court, I called upon Australia, and I quote, to act in such a way as to enable any order of the Court will make on the request for provisional measures to have its appropriate effects, in particular, to refrain from any act which might cause prejudice to the rights claimed by the Democratic Republic of Timor-Leste in the present proceedings." End of quote. As usual, I shall not read the introductory paragraphs of the order which set out the principal procedural steps. I shall also omit or summarize some paragraphs of the order, and I shall not read references to the Court's past decisions. I shall now begin the reading at paragraph 18 of the order. The Court may indicate provisional measures only if the provisions relied on by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded. But the Court need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. Timor-Leste seeks to found the jurisdiction of the Court in this case on the declaration it made on 21 September 2012 under Article 36, Paragraph 2 of the Statute, and on the declaration Australia made on 22 March 2002 under the same provision. In the course of the oral proceedings, Australia stated that while reserving its, and I quote, right to raise questions of jurisdiction admissibility at the merit stage, end quote, it would not be, and I quote again, raising those matters in relation to Timor-Leste's request for provisional measures, end of quote. The Court considers that the declarations made by both parties under Article 36, Paragraph 2 of the Statute appear prima facie to afford a basis on which it might have jurisdiction to rule on the merits of the case. The Court thus finds that it may entertain the request for the indication of provisional measures submitted to it by Timor-Leste. The power of the Court to indicate provisional measures under Article 41 of the Statute has as its object the preservation of the respective rights claimed by the parties in a case pending its decision on the merits thereof. It follows that the court must be concerned to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. Therefore, the court may exercise these powers only if it is satisfied that the rights asserted by the requesting party are at least plausible. Moreover, a link must exist between the rights which form the subject of the proceedings before the court on the merits of the case and the provisional measures being sought. Timor-Leste states that the rights which it seeks to protect are the ownership and property rights which it holds over the seized material, entailing the rights to inviolability and immunity of this property, in particular documents and data, to which it is entitled as a sovereign state, and its right to the confidentiality of communications with its legal advisors. Timor-Leste, moreover, holds that confidentiality of communications between legal counsel and client is covered by legal professional privilege, which it states is a general principle of law. Australia, for its part, contends that even assuming that the material removed from the business premises in Narrabundah does belong to Timor-Leste, a matter which in its view is yet to be established, there is no general principle of immunity or inviolability of state papers and property, and therefore the rights asserted by Timor-Leste are not plausible. It also contends that if there is a principle in international law whereby any state is entitled to the confidentiality of all communications with its legal advisors, that principle, akin to legal professional privilege, is not absolute. It does not apply when the communication in question concerns the commission of a crime or fraud, constitutes a threat to national security or to the higher public interest of a state, or undermines the proper administration of justice. At this stage of the proceedings, the court is not called upon to determine definitively whether the rights which Timor-Leste wishes to see protected exist. It need only decide whether the rights claimed by Timor-Leste on the merits and for which it is seeking protection are plausible. The court begins by observing that it is not disputed between the parties that at least part of the documents and data seized by Australia relate to the Timor Sea Treaty arbitration or to possible future negotiations on maritime delimitation between the parties, and that they concern communications of Timor-Leste with its legal advisors. The principal claim of Timor-Leste is that a violation has occurred of its right to communicate with its counsel and lawyers in a confidential manner with regard to issues forming the subject matter of pending arbitral proceedings and future negotiations between the parties. The court notes that this claim right might be derived from the principle of sovereign equality of states, which is one of the fundamental principles of international legal order and is reflected in Article 2, Paragraph 1 of the Charter of the United Nations. More specifically, equality of the parties must be preserved when they are involved, pursuant to Article 2, Paragraph 3 of the Charter, in the process of settling an international dispute by peaceful means. If a state is engaged in the peaceful settlement of a dispute with another state through arbitration or negotiations, it would expect to undertake these arbitration proceedings or negotiations without interference by the other party in the preparation and conduct of its case. It would follow that in such a situation, a state has a plausible right to the protection of its communications with counsel relating to an arbitration or to negotiations, in particular to the protection of the correspondence between them, as well as to the protection of confidentiality of any documents and data prepared by counsel to advise that state in such a context. Accordingly, the Court considers that at least some of the rights for which Timor-Leste seeks protection, namely the right to conduct arbitration proceedings or negotiations without interference by Australia, including the right of confidentiality of and non-interference in its communication with legal advisers, are plausible. The Court now turns to the issue of the link between the rights claimed and the provisional measures requested. The provisional measures requested by Timor-Leste are aimed at preventing further access by Australia to this seized material, at providing the former with information as to the scope of access of Australia to the documents and data seized, and at ensuring the non-interference of Australia in future communications between Timor-Leste and its legal advisers. The Court considers that these measures, by their nature, are intended to protect Timor-Leste's claimed rights to conduct, without interference by Australia, arbitral proceedings and future negotiations, and to communicate freely with its legal advisers, counsel and lawyers to that end. The Court thus concludes that a link exists between Timor-Leste's claimed rights and the provisional measures sought. The Court, pursuant to Article 41 of the Statute, has the power to indicate provisional measures when irreparable prejudice could be caused to rights which are the subject of the judicial proceedings before it. The power of the Court to indicate provisional measures will be exercised only if there is urgency, in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights in dispute before the Court gives its final decision. The Court must therefore consider whether such a risk exists at this stage of the proceedings. Timor-Leste claims that Australia's actions in seizing confidential and sensitive material from its legal advisor's office create a real risk of irreparable prejudice to its rights. Timor-Leste asserts that it is highly probable that most of the documents and data in question relate to its legal strategy, both in the context of the Timor Sea Treaty arbitration and in the context of future maritime negotiations with Australia. According to Timor-Leste, these, and I quote, matters are crucial to the future of Timor-Leste as a state and to the well-being of its people, end of quote. It states that the confidential material includes advice of counsel, legal assessments of Timor-Leste's position, and instructions given to counsel and to geological and maritime experts. Timor-Leste adds that it may already have been seriously harmed, given that Australia has admitted that some of the hard copy materials were briefly inspected during the search. In view of the sensitive nature of the seized material, Timor-Leste contends that, by its conduct, and I quote, Australia has placed itself in a position of considerable advantage, both in the pending arbitration and in a whole range of matters involved in the relations between Timor-Leste and Australia, end of quote. Timor-Leste affirms that the risk of irreparable prejudice is imminent because it is currently considering which strategic and legal position to adopt in order to best defend its national interests vis-à-vis Australia in relation to the 2002 Timor Sea Treaty and the 2006 Treaty on Certain Maritime Arrangements in the Timor Sea. Given that the preparations for the Timor Sea Treaty arbitration are well underway, with oral proceedings due to begin at the end of September 2014, Timor-Leste states that time is of the essence if irreparable damage is to be avoided. Timor-Leste contends that if the protection of its right is deferred until the close of the proceedings on the merits in the current case, the prejudice it would suffer would be increased. According to Australia, there is no risk of irreparable prejudice to Timor-Leste's rights. It states that the comprehensive undertakings provided by the Attorney General of Australia demonstrate that any rights which Timor-Leste may be found to possess are sufficiently protected pending final judgment in the current case. In this regard, Australia refers to various instructions and undertakings given by its Attorney General on 4, 19 and 23 December 2013, and in particular to a further written undertaking of the Attorney General given on 21 January 2014. Australia explains that on 4 December 2013, the Attorney General of Australia made a ministerial statement to Parliament on the execution by Australia's Security Intelligence Agency, ASIO, of the search warrants on the business premises of a legal advisor to Timor-Leste in Canberra. In his statement, the Attorney General indicated that the search warrants had been issued by him, and I quote, at the request of ASIO, on the grounds that the documents and electronic data in question contain intelligence relating to national security matters. End of quote. He emphasized, and I quote again, that the material taken into possession in execution of the warrants was not under any circumstances to be communicated to those conducting the arbitration proceedings on behalf of Australia. End of quote. Australia further notes that following the first procedural meeting of the Timor Sea Treaty Arbitral Tribunal, convened on 5 December 2013, the Attorney General of Australia provided a written undertaking to the tribunal dated 19 December 2013. In that undertaking, the Attorney General recalled the instructions given to ASIO and declared that the material seized would not be used by any part of the Australian government for any purpose related to the Timor Sea Treaty arbitration. Further, the Attorney General undertook that he would not make himself aware or otherwise seek to inform himself of the content of the material or any information derived from the material, and that, should he become aware of any circumstance in which he would need to inform himself, he would first bring that fact to the attention of the tribunal and offer further undertakings. Australia informed the court that following the letter of the President of this court under Article 74, Paragraph 4 of the Rules of the Court, the Attorney General of Australia wrote a letter dated 23 December 2013 to the Director General of Security of ASIO, directing that the measures set out in the undertaking to the Arbitral Tribunal on 19 December 2013 be implemented equally in relation to the proceedings instituted before the court. In his letter, the Attorney General stated in particular that it would be desirable and appropriate for Australia to satisfy the President's request by ensuring that from now until the conclusion of the hearings on 20 to 22nd January, the material is sealed, that it is not accessed by any other officer of ASIO, and that ASIO ensure that it is not accessed by any other person. At the start of Australia's first round of oral argument on the request for the indication of provisional measures, the Attorney General provided the court with a written undertaking dated 21 January 2014. Australia points out that this written undertaking contains comprehensive assurances that the confidentiality of the seized documents will be safeguarded. It points in particular to the following declarations made by the Attorney General in his written undertaking, and I quote, that until final judgment in these proceedings or until further or earlier order of the court, he will not make himself aware or otherwise seek to inform himself of the content of the material or any information derived from the material, and 2, should he become aware of any circumstance which would make it necessary for him to inform himself of the material, he will first bring that fact to the attention of the Court, at which time further undertakings will be offered. And 3, the material will not be used by any part of the Australian government for any purpose other than national security purposes, which include potential law enforcement referrals and prosecutions. And 4, without limiting the above, the material or any information derived from the material will not be made available to any part of the Australian government for any purpose relating to the exploitation of resources in the Timor Sea or related negotiations, or relating to the conduct of A, these proceedings, and B, the proceedings in the Arbitrary Tribunal constituted under the 2002 Timor Sea Treaty. In its oral pleadings, Australia affirmed that the Attorney General's written undertaking, dated 21st January 2014, would protect Timor-Leste's rights, and I quote, pending final judgment in these proceedings, end of quote. Moreover, during the oral proceedings, with reference to the letter dated 23rd December 2013 from the Attorney General of Australia to the Director General of Security of ACO, the Solicitor General of Australia stated that, and I quote, ACO to date has not inspected any of the documents, end of quote. He noted that ACO, and I quote, had not commenced its task because the documents were being kept under seal for all purposes until Australia had this Court's decision on provisional measures, end of quote, adding that, and I quote again, to date no information had been obtained from the documents, end of quote. With respect to the undertakings given by the Attorney General of Australia on 4th, 19th and 23rd December 2013, Timor-Leste argues that they are far from adequate to protect Timor-Leste's rights and interests in the present case. According to Timor-Leste, in the first place, they lack binding force, at least at the international level. Secondly, they are in serious respect more limited than the provisional measures requested by Timor-Leste, as they do not address the wider issues going beyond the Timor Sea Treaty arbitration. And thirdly, the instructions set out in the letter dated 23rd December 2013 from the Attorney General of Australia to the Director General of ACO are given only until the conclusion of the hearings in the present phase of the case. With reference to the written undertaking dated 21st January 2014, Timor-Leste asserts that it does not suffice to prevent the risk of irreparable harm, nor does it remove the urgency of Timor-Leste's request for the dedication of provisional measures. While Timor-Leste acknowledges that this written undertaking goes further than the previous assurances, in that it extends, and I quote, to maritime delimitation matters, end of quote, it contends that the written undertaking, quote, should be backed up by an order of the Court that deals with the treatment of the materials, end of quote. The Court is of the view that the right of Timor-Leste to conduct arbitral proceedings and negotiations without interference could suffer irreparable harm if Australia failed to immediately safeguard the confidentiality of the material seized by its agents on 3rd December 2013 from the office of a legal advisor to the government of Timor-Leste. In particular, the Court considers that there could be a very serious detrimental effect on Timor-Leste's position in the Timor Sea Treaty arbitration and in future maritime negotiations with Australia should the seized material be devolved to any persons or persons involved or likely to be involved in that arbitration or in negotiations on behalf of Australia. Any breach of confidentiality may not be capable of remedy or reparation, as it might not be possible to revert to the status quo ante following disclosure of the confidential information. The Court notes that the Attorney General of Australia gave a written undertaking to the Court on 21st January 2014, which included commitments to the effect that the seized material will not be made available to any part of the Australian government for any purpose in connection with the exploitation of resources in the Timor Sea or related negotiations, or in connection with the conduct of the current case before the court of the proceedings of the Timor Sea Treaty Tribunal. The court observes that the Solicitor General of Australia, moreover, clarified during the hearings, in answer to a question from a member of the court, that no person involved in the arbitration or negotiation has been informed of the content of the documents and data seized. The court further notes that the agent of Australia stated that, and I quote, "The Attorney General of the Commonwealth of Australia had the actual and ostensible authority to bind Australia as a matter of both Australian law and international law," end of quote. The court has no reason to believe that the written undertaking dated 21st January 2014 will not be implemented by Australia. Once a state has made such a commitment concerning its conduct, its good faith in complying with that commitment is to be presumed. The court, however, takes cognizance of the fact that in paragraph 3 of his written undertaking dated 21st January 2014, the Attorney General states that the seized material will not be used, and I quote, "by any part of the Australian government for any purpose other than national security purposes, which include potential law enforcement referrals and prosecutions," end of quote. The Attorney General underlined in paragraph 2 that, quote, "should he become aware of any circumstance which would make it necessary for him to inform himself of the material, he would first bring that fact to the attention of the court, at which time further undertakings will be offered," end of quote. Given that in certain circumstances involving national security, the government of Australia envisages the possibility of making use of the seized material, the court finds that there remains a risk of disclosure of this potentially highly prejudicial information. The court notes that the Attorney General of Australia has given an undertaking that any access to the material for considerations of national security would be highly restricted, and that the contents of the material would not be divulged to any persons involved in the conduct of the Timor Sea Treaty arbitration, in the conduct of any future bilateral negotiations on maritime delimitation, or in the conduct of the proceedings before this court. However, once disclosed to any designated officials in the circumstances provided for in the written undertaking dated 21st January 2014, the information contained in the seized material could reach third parties, and the confidentiality of the materials could be breached. Moreover, the court observes that the commitment of Australia to keep the seized material sealed has only been given until the court's decision on the request for the indication of provisional measures. In light of the above, the court considers that the written undertaking dated 21st January 2014 makes a significant contribution towards mitigating the imminent risk of irreparable prejudice created by the seizure of the above-mentioned material to Timor-Leste's rights, particularly its right to the confidentiality of the material being duly safeguarded, but does not remove this risk entirely. The court concludes from the foregoing that, in view of the circumstances, the conditions required by its statute for it to indicate provisional measures have been met insofar as, in spite of the written undertaking dated 21st January 2014, there is still an imminent risk of irreparable prejudice as demonstrated above. It is therefore appropriate for the court to indicate certain measures in order to protect Timor-Leste's rights pending the court's decision on the merits of the case. The Court recalls that it has the power under its statute, when a request for provisional measures has been made, to indicate measures that are in whole or in part other than those requested. Article 75, paragraph 2 of the Rules of Court specifically refers to this power of the Court. The Court has already exercised this power on several occasions in the past. In the present case, having considered the terms of the provisional measures requested by Timor-Leste, the Court finds that the measures to be indicated need not be identical to those requested. The Court notes that the Solicitor General of Australia clarified during the oral proceedings that the written undertaking of the Attorney General of 21st January 2014 will not expire without prior consultation with the Court. Thus, this undertaking will not expire once the Court has ruled on Timor-Leste's request for the indication of provisional measures. As the written undertaking of 21st January 2014 does not contain any specific reference to the seized documents being sealed, the Court must also take into account the durations of Australia's commitment to keep the said material under seal contained in the letter dated 23rd December 2013 from the Attorney General of Australia to the Director General of ACO. The Court takes note of the fact that under the terms of that letter, the commitment was given until the close of the oral proceedings on the request for the indication of provisional measures. The Court further observes that during the oral proceedings, Australia gave assurances that the seized material would remain sealed and kept inaccessible until the Court had rendered its decision on that request. Given the likelihood that much of the seized material contains sensitive and confidential information relevant to the pending arbitration, and that it may also include elements that are pertinent to any future maritime negotiations which may take place between the parties, the Court finds that it is essential to ensure that the content of the seized material is not in any way or at any time divulged to any persons or persons who could use it or cause it to be used to the disadvantage of Timor-Leste in its relations with Australia over the Timor Sea. It is therefore necessary to keep the seized documents and electronic data and copies thereof under seal until further decision of the Court. Timor-Leste has expressed concerns over the confidentiality of its ongoing communications with its legal advisers concerning in particular the conduct of the Timor Sea Treaty arbitration, as well as the conduct of any future negotiations over the Timor Sea and its resources, a matter which is not covered by the written undertaking of the Attorney General of 21st January 2014. The Court further finds it appropriate to require Australia not to interfere in any way in communications between Timor-Leste and its legal advisers, either in connection with the pending arbitral proceedings and with any future bilateral negotiation concerning maritime delimitation, or in any connection with any other related procedure between the two states, including the present case before the Court. The Court reaffirms that its orders on provisional measures under Article 41 of the Statute have binding effect and thus create international legal obligations for any party to whom the provisional measures are addressed. The decision given in the present proceedings in no way prejudges the question of the jurisdiction of the Court to deal with the merits of the case or any questions relating to the admissibility of the application or relating to the merits themselves. It leaves unaffected the right of the governments of Timor-Leste and Australia to submit arguments in respect of those questions. For those reasons, the Court indicates the following provisional measures. 1. By 12 votes to 4, Australia shall ensure that the content of the seized material is not in any way or at any time used by any person or persons to the disadvantage of Timor-Leste until the present case has been concluded. In favor, President Tomka, Vice President Sepulveda Amor, Judges Ovada, Abraham, Benuna, Skotnikov, Kansa de Trindade, Yusuf, Sway, Gaia, Bandari, Judge ad hoc, Cott. Against, Judges Keys, Greenwood, Donoghue, Judge ad hoc, Cullinan. 2. By 12 votes to 4, Australia shall keep under seal the seized documents and electronic data and any copies thereof until further decision of the court. In favor, President Tomka, Vice President Sepulveda Amor, Judges Ovada, Abraham, Benuna, Skotnikov, Kansa de Trindade, Yusuf, Sway, Gaia, Bandari, Judge ad hoc, Cott. Against, Judges Keys, Greenwood, Donoghue, Judge ad hoc, Cullinan. 3. By 15 votes to 1, Australia shall not interfere in any way in communications between Timor-Leste and its legal advisors in connection with the pending arbitration under the Timor Sea Treaty of 20 May 2002 between Timor-Leste and Australia, with any future bilateral negotiations concerning maritime delimitation, or with any other related procedure between the two states, including the present case before the court. In favor, President Tomka, Vice President Sepulveda Amor, Judges Ovada, Abraham, Keys, Benuna, Skotnikov, Kansa de Trindade, Yusuf, Greenwood, Sway, Donoghue, Gaia, Bandari, Judge ad hoc, Cott. Against, Judge ad hoc, Cullinan. I shall now call upon the Registrar to read the French text of the operative part of the order. Vous avez la parole, Monsieur le greffier.
Merci. Par ces motifs, la Cour indique à titre provisoire les mesures conservatoires suivantes. 1. Par 12 voix contre 4, l'Australie fera en sorte que le contenu des éléments saisis ne soit d'aucune manière et à aucun moment utilisé par une quelconque personne au détriment du Timor-Leste, et ce, jusqu'à ce que la présente affaire vienne à son terme. Pour M. Tomka, président, M. Sepulveda Amor, vice-président, M. Ouada, Abraham, Benuna, Skotnikov, Kansa de Trindade, Youssouf, Mme Choué, M. Gaia Bandari, juge, M. Cott, juge ad hoc. Contre, M. Keith, Greenwood, Mme Donoghue, juge. M. Cullinan, juge ad hoc. 2. Par 12 voix contre 4. L'Australie conservera sous scellé les documents et données électroniques saisis, ainsi que toute copie qui en aurait été faite, jusqu'à toute nouvelle décision de la Cour. Pour M. Tomka, président, M. Sepulveda Amor, vice-président, M. Ouada, Abraham, Benuna, Skotnikov, Kansa de Trindade, Youssouf, Mme Choué, M. Gaia Bandari, juge. M. Cott, juge ad hoc. Contre, M. Keith, Greenwood, Mme Donoghue, juge. M. Cullinan, juge ad hoc. 3. Par 15 voix contre 1, l'Australie ne s'ingérera d'aucune manière dans les communications entre le Timor-Leste et ses conseillers juridiques, ayant trait à l'arbitrage en vertu du traité du 20 mai 2002 sur la mer de Timor, actuellement en cours entre le Timor-Leste et l'Australie, à toute négociation bilatérale future sur la délimitation maritime, ou à toute autre procédure entre les deux États qui s'y rapportent, dont la présente instance devant la Cour. Pour M. Tomka, président, M. Sepulveda Amor, vice-président, M. Ouada, Abraham, Keith, Benuna, Skotnikov, Kansa de Trindade, Youssouf, Greenwood, Mesdames Choué, Donoghue, M. Gaia Bandari, juge. M. Cott, juge ad hoc. Contre, M. Cullinan, juge ad hoc.
Merci, Monsieur le greffier. Judge Keys appends a dissenting opinion to the order of the court. Judge Cansado Trindade appends a separate opinion to the order of the court. Judge Greenwood appends a dissenting opinion to the order of the court. Judge Donoghue appends a separate opinion to the order of the court. Judge ad hoc Cullinan appends a dissenting opinion to the order of the court. The text of the order is available from today in TypeScript. It will also be available later today on the court's website. The printed text will be published as soon as possible. There being no other matters before the court today, I declare the sitting closed.